Welcome back. I am Miss Sini and I'm an intern in LEXIS and Company. The topic which we are going to deal today is the legal news, which is breaking news that happened today in the Supreme Court, and that is that the Supreme Court upholds provision of insolvency and bankruptcy code on insolvency of personal guarantors. So let's get started and let's see the news in detail. The Supreme Court of India today upheld provisions for Insolvency and Bankruptcy Code IBC relating to the insolvency of personal guarantors that they were brought into force in 2019 in the case of Lalit Kumar Jain versus Union of India. The bench of Justice L. Nageshwar Rao and Ravindra Bhatt delivered the judgment after the apex court transferred it to itself. Petitions challenging a notification dated November 15, 2019, enforcing certain provisions of the IBC related to insolvency of the personal guarantors. The notification also had enacted a number of rules on the insolvency resolution process for personal guarantors to cooperate debtors. The Insolvency and Bankruptcy Board of India (IBBI) has sought the transfer of all the matters pending before the High Court to the Supreme Court so as to avoid conflicts ruling by different courts. All these pending writ petitions challenged the constitutional validity of Part 3 of IBC, which deal with insolvency resolution for individual and partnership firm. Top Court, while transferring all the petition to itself in October last year, had stated that IBC was at the nascent stage and it was the better for the court to take up the interpretation of the provision of the code so as to avoid any confusion and to authoritatively settle the law. Considering the importance of the issue raised against the writ petition, which needed finality of judicial determination at the earliest, it is just and proper that the writ petitions are transferred from High Court to the Supreme Court. The Supreme Court had noted in this order. Writ petitions was filed in the Delhi High Court and other High Court challenging the 2019 notification and the insolvency and bankruptcy application to adjudicating authority for insolvency resolution process of personal guarantors to cooperate debtor rule 2019 as well as the number of similar rules. The petitioners also sought the section 95, 96, 99, 100, 101 of the IBC to be declared unconstitutional insofar as they apply to personal guarantors of corporate debtors. Vide the 2019 notification, the Union Ministry of Corporate Affairs had brought into force the following provisions of the IBC insofar as they related to personal guarantors to incorporator debtor. The following provisions are: first is Clause E of Section 2, second is Section 78, except with regard to the fresh start process, and Section 79. Third is Section 94 to Section 187, inclusive of both the sections. Fourth is Clause G to Clause 1 of Subclause 2 of Section 239. Fifth is Clause M to Clause ZC of Subclause 2 of Section 339. Sixth is Clause ZN to Clause ZS of Subsection 2 of Section 240. And last of Section 249. So these was the recent judgment of the Supreme Court on the Insolvency and Bankruptcy Code. So I hope that this video helped you to understand the Supreme Court's rule easily. So we'll meet in the next video. Till then, take care, stay safe. Thank you.